Welcome to the Scaringi Law Lunch Break. This is your time of the day to learn a little bit about the law while you enjoy your lunch. Today's topic, the United States Supreme Court's most recent abortion case. Justice Roberts disappoints where Justice Thomas delights. On June 29, 2020, United States Chief Justice John G. Roberts let down constitutional conservatives once again, this time on abortion. In June Medical Services LLC et al. V. Russo, interim secretary of the Louisiana Department of Health and Hospitals, Roberts cast the tie-breaking vote, striking down a Louisiana law requiring abortion doctors to obtain admitting privileges at a local hospital in order to protect women's health. What made Roberts' vote even more disappointing is that he voted the opposite way a few years ago in a nearly identical case in which the court struck down a similar Texas abortion law on the same grounds. Now, to be fair, Roberts dissented in that case mainly because of the doctrine of res judicata. The claims brought by the Texas abortion providers had already been heard and dismissed in a prior case, and thus should not have been raised again. However, in that case, Roberts explained that he would have allowed the Texas law to stand in those geographical areas in which it was easy for abortion doctors to obtain admitting privileges. But in the Louisiana case, the one just decided, Roberts shut the door on these laws entirely. Why? Roberts claims the doctrine of stare decisis made him do it. Stare decisis means to stand by things decided. It's the legal term for fidelity to precedent. Roberts quoted the eminent legal scholar William Blackstone, who wrote, "It has long been an established rule to abide by former precedents, where the same points come in judgment again in litigation, as well as to keep the scale of justice even and steady, and not liable to waver with every new judge's opinion." Stare decisis, however, is not law and is not in the Constitution. Its application in cases involving erroneous prior decisions is particularly jolting. Stunningly, Roberts declared that even though he still believes the Texas case was wrongly decided, he chose to apply its holding to the Louisiana case. Roberts argued that by applying a prior decision he believes to be wrong, he is, to paraphrase Alexander Hamilton in Federalist 78, avoiding an arbitrary discretion in the courts. Well, in short, Roberts believes it's better for the court to be consistently wrong than for it to correct bad decisions. Do you think that Roberts would state publicly that previous decisions such as Dred Scott, in which the court held that black Americans were not United States citizens, and Plessy v. Ferguson, in which the court upheld racial segregation laws for public facilities, should not have been overturned because of stare decisis? Not in a million years. Ralph Waldo Emerson wrote, "A foolish consistency is the hobgoblin of little minds adored by little statesmen and philosophers and divines." Any rational layperson understands the absurdity of continuing to apply bad law. Yet the Chief Justice is often referred to as one who acts the statesman, who understands the importance of the reputation of the court, and as a result, he votes down the middle of the road in controversial cases in order to protect the court. But he's wrong. Roberts is not protecting the court. He is harming the court, the rule of law, and the Constitution when he continues to apply bad law to new cases. However, where Roberts disappoints, Justice Clarence A. Thomas delights. In a dissenting opinion, Thomas lit a torch to the court's abortion jurisprudence. Thomas declares, referring to the court's infamous decisions in Roe v. Wade and Planned Parenthood v. Casey, those decisions created the right to abortion out of whole cloth, without a shred of support from the Constitution's text. Our abortion precedents are grievously wrong and should be overruled. That's Justice Thomas. He correctly explains the court's current formulation of the stare decisis standard does not comport with our judicial duty under Article 3, which requires us to faithfully interpret the Constitution. In short, the United States Constitution is the supreme law of the land, not prior Supreme Court decisions. And justices must do their duty to interpret and uphold the Constitution. Regrettably, no other justice joined Thomas's dissent. The 4 members of the liberal wing of the court will always act to further solidify the purported right to abortion. They now have an ally in Roberts, giving them the 5th and tie-breaking vote. Through Roberts and his application of stare decisis, the court, as it is currently constituted, will continue the legal farce that there is a right to abortion in the United States Constitution. This is bad news for those who believe in the right to life and for the lives of the innocent unborn. Well, that's all the time we have today for the Scaringi Law Lunch Break. I hope you learned a little bit about the law. Thanks for listening and enjoy your lunch.